Any mention?
My lord, I beg to mention item number 13, my lord. Two weeks. 2 weeks, my lord. 13, 2 weeks.
May I please, Your Lordship?
Yes.
I would like to make a mention of item number 15, Your Lordship. May it come after 2 weeks, Your Lordship.
2 weeks.
Deeply obliged, Your Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 20, Your Lordship. I pray for 3 weeks' time, Your Lordship. Item 20.
2 weeks.
3 weeks, Your Lordship.
2 weeks.
Obliged.
May I please, Your Lordship? I beg to mention item number 7, my lord. On behalf of respondent number 4, my lord. I'm praying for a short period of time, my lord, 1 week.
No objection, Your Lordship.
2 weeks.
My lord, I beg to make a mention of item 8, my lord, 8, then my lord item 9, my lord item 16.
Why?
And 19. My lord, here Mr. R. Goring is the conducting counsel, my lord. Some bereavement, so that is it. Item 16? Yes, item 16.
Wow. Arguing.
Mr. R. Goring is not available today, my lord. He is a conducting counsel.
Authorised.
8, 9, 16 and 19, my lords. 20 is mentioned.
8 and 9, 1 week. Then 10.
No, lords. Then thereafter it is 16 and 19.
8, 9 and 16.
16 and 19, my lords.
8, 16, 19.
My lord, for item number 9, I have already submitted my written argument, my lord.
Item 19.
2
9
weeks.
I'm not there.
16, 2 weeks. Huh?
Oh, 9.
3 weeks, sir. 2 weeks. 19.
19, I am appellant, my lord.
Have you started?
No, my lord, is not yet.
3 weeks.
But item 21, I beg to mention them.
21. Item 21.
Oh, 21.
Yes, Lordship. No objection.
3 weeks.
No objection.
On daily list, item number 1.
This is a legal matter after the condonation.
I mean, please, my lordship. Lordship, in terms of the last order, my lord, we are directed to produce what, my lord? But actually, Mr. Ansinkon, he has some submissions to meet, my lord. He's on next before court too. So, my lord, I'm praying if the matter can come on Thursday, my lord. And in the meantime, we'll get the copy of the award, my lord.
Copy of the award has not been. Copy of
Lordship,
the award
we
has
are getting it done, my lord. In fact, Mr. Ansinkon, he has some submissions.
on pre-made. This is matter after 1 week.
Highly
Alright,
obliged,
my
Lordships.
Any mention?
Your Lordship, I beg to mention item number 13. I'm praying for some accommodation, Your Lordship. Senior counsel is on sanction leave, Your Lordship.
It's an old matter.
It is an old matter, my lord. We are representing respondent number 3 is the same of Nobosupo. Since senior counsel is not there, my lord, to make short accommodations maybe.
1 week.
1 week. Right. Much obliged.
Your Lordship, similar prayer for item number 5 to 11, Your Lordship. Short date may be given, Your Lordship.
But this matter is supposed to be heard here
Yes, Your Lordship, on our part.
by state first.
By
No,
the state and then money committee and the private respondent also are there, Your Lordship.
You are for
The principal and the managing committee, 4 and 5.
then we can hear you.
Lordship, yes.
Yeah, you can note down. You see whatever. Otherwise, if we keep on making adjournment with this matter will not end. Maybe next date we'll hear you.
Lordship.
Daily list item number 1.
Then WPC number 480 of 2018, Your Lordship, and WPC number 481. These are same analogous, Your Lordship, identical fact, Your Lordship. Here the case center around non-payment of salary, Your Lordship. Lordship, we file our affidavit, Your Lordship. Before Lordship, I come to first read petition number 470 of 2018, Your Lordship.
You make your submission case-wise or?
Case-wise, Lordship, I'm coming case-wise. Lordship, kindly have a first WPC number 470 of 2018. Yes. Give me the file. Give me the affidavit. Lordship, here the admitted fact is done. The admitted fact is that, Your Lordship, the order of termination, Your Lordship, of the writ petitioner, that has been set aside by the director, Your Lordship. On the ground that the procedure followed, the action taken, Your Lordship, was not as per the procedure, Your Lordship. Then, so far the salary part is concerned, Lordship will kindly have the affidavit of the state file at paragraph 15. Lordship, kindly have para 15 of the affidavit, Your Lordship.
Yes, sir.
Para
Yes,
15.
when was the affidavit filed?
This affidavit was filed, Your Lordship, on 24/7/2019, Your Lordship. Lordship, that date, Lordship will find it at page 5, the last paragraph, Your Lordship, and I signed this affidavit.
Yes.
Para 15, Your Lordship. Lordship, I kindly see the principal after paying certain salary to some teacher, Your Lordship, an amount of 3,12,000 has been refunded, Your Lordship, to the district school education officer Tuva. So the state, Your Lordship, did not fail in its duty to release the salary payable to the writ petitioner, Your Lordship. Then, Lordship, kindly have a writ petition 471, Your Lordship.
Where is in support of your contention? Have you?
No, Your Lordship, but this is this statement, Your Lordship. This statement, Your Lordship, was not disputed by the writ petitioner, Your Lordship.
Okay.
Lordship, out at 13,96,000, Your Lordship, has been released to the principal. Out of that, Your Lordship, 3,12,000, Your Lordship, has been refunded, Your Lordship, to the DSTO, Your Lordship.
Yes.
Then, Lordship, kindly have writ petition number 471, Your Lordship. Yes, 471. No, there. If Lordship kindly have a page 11, Your Lordship, the relief claim in the writ petition, Your Lordship, is mainly salary, Your Lordship.
Yes.
This salary, Your Lordship, is with effect from December 2016 and January 2018, Your Lordship. And to that, Your Lordship, we have filed the affidavit, Your Lordship. We have filed the affidavit, Your Lordship. Lordship, kindly have a para 12 of the affidavit. This is same, Your Lordship. 13 lakhs 96,000 had been released, and out of that, Your Lordship, 3 lakhs 12,000 had been refunded, Your Lordship. Para 12, Your Lordship. In read petition number 71 is a para 12, Your Lordship.
It's also same.
Same, Your Lordship, yes. Then give me a read petition number 480. Give me the read petition. Lordship, in WPC number 480, Your Lordship. This is same, Your Lordship, as a read petition number 471, Your Lordship. Salary payable is for the same period, Your Lordship. In this, Your Lordship, Lordship will find the statement of the official respondent, Your Lordship. Lordship, kindly have a para 18 at page 7.
Yes.
That 13 lakhs 96,000 same, Your Lordship. Then at the same time, Your Lordship, kindly see, Your Lordship, there was also a direction to conduct an inquiry against the principal, Your Lordship, for the alleged misappropriation, Your Lordship, of the salary of the teachers, Your Lordship. Lordship will that statement, Lordship will find at para 19 of the affidavit, Your Lordship. And what happened, Your Lordship? Maybe the principal, Your Lordship, as Lordship, maybe he was not pleased with the action taken, Your Lordship. What happened? He refunded whatever fund had been, whatever fund which had been released by the government. He refunded back that money, Your Lordship, amounting to 3,12,000, Your Lordship, to the DSEO, Your Lordship. It's same, Your Lordship. Lordship will find, if Lordship kindly have the inquiry, Your Lordship, the inquiry at page 17. This is the inquiry, Your Lordship. This is the inquiry conducted, Your Lordship, against the principal.
Page 17.
Page 17, Your Lordship. Page 26, Your Lordship, Annexure 7. Lordship, kindly have page 28, Your Lordship. That is the finding. Kindly see the finding against the principal, Your Lordship.
Yes.
Lordship, kindly see. Shri Islam Sheikh Chaudhary, Principal Karudubi Higher Secondary.
You're reading from your...
This, Lordship, I'm reading from my affidavit, Your Lordship, at page 28, Your Lordship. My affidavit, Your Lordship.
28?
Lordship, it starts from 26. That is the inquiry of dated 23rd June 2017, Your Lordship.
Just a moment. This is your affidavit, did it?
This is the affidavit, just a minute, Lordship, kindly. Filed on 27/5/2019, Your Lordship.
By Shri P. Rangsai.
Lordship, by Shri Piring Sai, Your Lordship, yes.
Page 28.
Page 26, Your Lordship, 26.
26.
No, page 17.
Page 17, Your Lordship. On top, 17, then
Annexure 5.
Annexure 5, Your Lordship.
5.
Lordship, yeah. I'm sorry, Lordship. Even also I get confused with the paging. Lordship, kindly 17, Your Lord.
Yes.
By
Lordship.
inspection committee.
Lordship, yes. Then Lordship, kindly have page 19, the finding against the principal, Your Lordship.
Yes.
Then Lordship, kindly see the inquiry, the finding of the inquiry, Your Lordship. Lordship, kindly see 3.
Yes.
3 and 4, Your Lordship. Principal Shri Islam Hik Chaudhary should be refunded, should be his appropriate amount for which he had drawn double salary and the salary drawn in the name of Shri Samuel Islam, a host teacher. Then, Lordship, the action taken, Your Lordship, will find at page 30, at page 21, Your Lordship. That is the order passed by the Deputy Commissioner, Tura. He has been demoted, Your Lordship, from the post of principal to the post of assistant teacher.
Yes, Annexure 6.
Lordship, yes.
Yes.
Then, Lordship, kindly have a page 24.
Yes.
There was a show cause notice, Your Lordship, to the principal.
Yes.
Regarding that misappropriation of their salary, Your Lordship.
Yes.
Then the salary for the teacher, Your Lordship, which had been released to the principal, Your Lordship, will find at page 29 of the affidavit, Your Lordship. That amount is 13,96,000, same with the other cases, Your Lordship, because these are from the same school, Your Lordship.
Yes.
And this, Lordship, so far the salary part, Your Lordship, that the salary had been released by the state, Your Lordship, to the principal, Your Lordship, that has also admitted, Your Lordship, by the writ petitioner at para 6 of the writ petition, Your Lordship. Kindly have a para 6, Your Lordship, of the writ petition. Lordship will find it at page 4. So far, the payment of salary, Your Lordship. So they got the salary, Your Lordship.
Yes. What does it say?
Lordship, it say that the petition state that the government of Meghalaya, with effect from September 2, has enhanced this monthly salary of teacher, Your Lordship. That is correct. From 10,000 to 20,000, the enhanced salaries with effect so and so was withdrawn by the principal. However, 2 months so and so was paid to the patient by the principal on 2 occasions and so and so. So the admitted fact, Your Lordship, yes, the salary had been paid, Your Lordship, to certain teachers, Your Lordship, and the rest of the money, Your Lordship, amounting to 3,12,000 that had been refunded by the principal, and for what reason, Your Lordship, the principal will have to answer, Your Lordship.
Yes.
Then, Lordship, kindly have page writ petition number 481, Your Lordship. With the writ petition. This also, your lordship, if lordship kindly have page 11, your lordship, that is the relief claim in the writ petition. Writ petition number 481, your lordship.
Yes, this one.
Lordship kindly have a page 11. Lordship, that is for the payment of salary November, December 2016, then to January 2008 till
Page
date.
11 of
Lordship.
what?
Lordship.
Page 11 of the.
This is writ petition number 481, Shri Akbar Ali Khan.
Yes, and you are referring to?
Lordship, the relief claim, your lordship, is same, your lordship. I have sought out the petition, your lordship,
Okay.
which writ petition are the same relief claim. Then, lordship, we file the affidavit, your lordship. Lordship, kindly have our affidavit, your lordship.
Yes.
Lordship, kindly have page 3, your lordship, paragraph 9. Whatever salary, your lordship, payable to the teacher of that particular school has been drawn, your lordship, by the principal as well as by the school managing committee.
Yes. Para 9.
Lordship, yes. Then, lordship, kindly have paragraph 18 and 19 at page 7 and 8, your lordship.
Yes.
The same amount, your lordship, that 13,96,000, your lordship, that has been released, your lordship,
Yes.
and 3,12,000 had been refunded, your lordship. After payments certain salary to certain teacher, your lordship, what the principal has done and the school committee had done, your lordship, they have returned, your lordship, the salary of rupees 3,12,000, your lordship, back to the office, your lordship. Then, lordship, kindly have writ petition number 479, your lordship. What is the prayer made in the writ petition? Lordship will kindly have at page 10. Page 10, your lordship.
Yes.
Page 10, your lordship. That letter dated 31/3/2018, lordship will kindly turn to page 36 of the writ petition. If I may read, your lordship.
Just a moment. This is the, you're looking at the amended writ petition.
Lordship.
You're reading from the amended writ petition.
Lordship.
From the main petition.
From the main petition, your lordship, not for.
Because of change of the managing committee, the pleadings remain the same.
Lordship, the pleading is all the same, your lordship. And you have the original writ petition, your lordship.
Parties changed.
No, we have to look at the amended petition.
Lordship, then.
Yes, and there will be page 10.
It's same, your lord. It's all same, your lordship.
Yes. Then?
Lordship, they have not enclosed that, your lordship. It appears. page. Lordship, kindly bear with me. Page 36. This part they have not enclosed.
No, they have enclosed. Page 36 is the letter dated 31 March.
Lordship, yes. No, this is 479. They have not enclosed, your Lordship. In the amended writ petition, they have not enclosed, it appears, your Lordship.
It is here, annexure 16.
16.
Page 36.
This is the page number, sir. 36. Page 36. 36.
36 is there, your Lordship, from the main, from the unamended, from the original.
Amended also is here.
It's there, his.
Where is it?
20, 28. This is 28.
28.
29, 31, 33, 35, 46 is the same.
Oh, Lordship, yes.
It's there.
Can you see, your Lordship? With reference to the subject cited above, I am to state that Muhammad Ali Akbar, BSc, was appointed by Shri P.K. Hajong, the former inspector of school, so-and-so, while Karudibi was placed under the district administration based on the mark sheet of single subject in mathematics with 30 marks in the higher secondary examination science stream all course. However, that 30 marks single subject in mathematics, the mark sheet of Muhammad Ali Akbar bearing a roll number so submitted by him was tampered one and was actually issued to Muhammad Hasrat Ali, which was verified by the Assam Higher Secondary Education Council, so-and-so, Kawati. In this connection, Muhammad Ali, who has no in the higher secondary stream, cannot be considered as the science teacher in the Karudubi then secondary school was for the creative interest of the student committee. Therefore, directed the school managing committee so-and-so to replace him by the BSc Royal as the teacher to enable the undersigned to submit the proposal. Then what happened, your Lordship? What happened, your Lordship? Lordship, kindly have the order passed by the district school education officer. Lordship will find at page 37.
37.
Lordship, yes. His appointment has been cancelled, your Lordship. Has been cancelled. It has been cancelled, your Lordship. By the said appointment, your Lordship, there was a stipulation, your Lordship. If Lordship kindly have the letter dated 21/3/2018, that is annexure 12. In the unamended amended petition, your Lordship will find it at page 12, your Lordship.
Annexure 12, sir.
Page 12.
Page
12. Page 12, your Lordship.
Of the writ petition?
Lordship.
Annexure 12, page 32. Written page 32.
Lordship.
This order dated 29 September?
No, your Lordship.
Page 32, sir.
32 in the writ petition, in the main writ petition, your Lordship.
32.
30.
Annexure 12.
32, your Lordship. No.
Page 32.
Lordship, kindly have a page 32. 32, Your Lordship. Lordship, kindly have page 32, Your Lordship. On the condition, there is a stipulation, Your Lordship.
This is dated what?
21st March 2018, Your Lordship. There is a stipulation, Your Lordship, that he should pass, he should complete mathematics as one of this subject, Your Lordship.
Yes.
Lordship, because in this case, Your Lord, in this particular case, Your Lordship, there is a allegation that the mark sheet has been tampered, Your Lordship. Lordship will find it at page 28.
28?
28 of the amended writ petition, Your Lordship.
Yes, the mark sheet.
Mark sheet, yes, Your Lordship.
Yes.
Lordship, kindly see, Your Lordship, there is no mathematics in that.
Yes.
There is no mathematics paper, Your Lordship, in that. Then what happened, Your Lordship? Another
Yes.
just a minute, please, Your Lordship. Yes. Lordship, that mark sheet is there, Your Lordship. That mark sheet is there, Your Lordship. As I have submitted, Your Lordship, that stipulation is there, Your Lordship. We do not know, Your Lordship, whether he has got that mathematics as one of the subject or not. There is nothing, Your Lordship, to be said in the writ petition. Lordship, it appears from this writ petition, Your Lordship, that, as I have said, Your Lordship, there is a certain allegation of a teacher, Your Lordship, having a doubtful mark sheet of having appointed, Your Lordship, to the post of assistant teacher, Your Lordship.
But this is a subject matter of criminal proceedings.
Lordship, yes. Lordship, he filed that subsequently, Your Lordship. It appears, Your Lordship, that the person it appears, Your Lordship, he has been. Where is that? Lordship, they filed that additional affidavit to bring on record. It appears, Your Lordship, that if Lordship kindly have the affidavit to bring on record the order passed on 11/11/2025, passed by the learned judicial magistrate, Your Lordship, that is Fulbari, Waskar Hill District. It appears, Lordship, that he has been discharged. He has been discharged from the liability of that case, Your Lordship. There was a criminal case also lodged against this person, Your Lordship.
Where you're referring to?
Lordship, there is an affidavit. That affidavit is,
Where is that affidavit?
Lordship, that has been filed December 2025, Your Lordship. The affidavit by the petitioner placing on record order dated 11/11/25, passed in GR case number 25 of 23.
Yes, sir.
If I may assist, Your Lordship.
Yes.
Lordship has got that. Lordship, kindly have page Annex 1 at page 3, Your Lordship. Lordship, kindly stay away, come to page 8.
Yes.
So he has been discharged, Your Lordship. Has been discharged, Your Lordship. Lordship, in my humble and respectful submission, Your Lordship, the criminal trial stand on a different footing, Your Lordship, because Your Lordship, it appears from the record, we do not know, Your Lordship, whether whether that is tampered, forged marksheet, Your Lordship. For this, Your Lordship, to find out the truth, Your Lordship. Lordship, my humble and respectful submission, Your Lordship, considering the fact, Your Lordship, in all the writ petition, Your Lordship, that there is an allegation, Your Lordship, of non-payment of salary. Yes. Your Lordship, the state had released the salary, Your Lordship. The principal as well as the school money committee, Your Lordship, they have refunded, Your Lordship, the salary payable to the petitioner. For what reason, Your Lordship, we do not know, Your Lordship.
Yes.
Coupled with the fact, Your Lordship, that there is an allegation, Your Lordship, of a teacher having no required qualification based on a tampered document, Your Lordship, that had been appointed, Your Lordship. My humble and respectful submission, Your Lordship, if Lordship is pleased to order an inquiry, Your Lordship, to find out the matter, Your Lordship, in a similar, Lordship, almost a similar, Your Lordship, I would not say exactly, Your Lordship, this honorable court, Your Lordship, in series of writ petition, Lordship. In the case of Nasila Begum, Your Lordship. Where is that? Last order. The last order. No, not this one. The last order, the dispose order. No. Lordship, I'm sorry, that is not the, that is the order 24/11/2023. Where is that? Another one for me. Where is that? Where is that? Oh, I don't know what kind of, what you have done here, Rosie. I told you to check again. I told you to, what you have done here, Rosie. 383.
Para?
Lordship, just a minute, kindly. Lordship, if Lordship kindly have the paragraph 12 of that, Lordship, of that order, Lordship. What can be cleaned from the report? Para 12, your Lordship, onwards, Lordship, yes.
Yes.
Para 12 onward, your Lordship.
Yes.
Then thereafter, Your Lordship kindly have para 15. Para 15, Your Lordship. And then, Lordship, this honorable court was pleased to direct for a police inquiry, Your Lordship. So, Lordship, the order directing for the inquiry, Your Lordship. Lordship, this is the order, Your Lordship.
Against the petitioner?
Against Nurul Amin, Your Lordship.
Is he connected
Lordship?
to this case?
Lordship, because it's almost the fact, Your Lordship, I may not say, Your Lordship, the fact are similar, Your Lordship, but the affairs, Your Lordship, the happening, the affairs, Your Lordship, in the school, Your Lordship, more or less the same, Your Lordship.
Okay.
If Lordship kindly have a para 5 for that order, para 5 for the order dated 7/2/23, Your Lordship.
Yes.
In the backdrop of this sordid state of affairs, this court, while hearing this batch of matter, find it impossible to adjudicate effectively in view of the contradictory, inconsistent, and unreliable report that have been furnished from time to time. It is therefore considered expedient and in the interest of justice and public interest, especially the children of the said school of the area, that a fresh inquiry be conducted to ascertain the correct picture and also to fix responsibility on the official, as also the teacher who have caused this confusion. It is therefore directed an inquiry into the affairs of the so-and-so school from its inception after it was put under till date be conducted, Your Lordship. This is the order, Your Lordship. If Lordship, my prayer before this honorable court is, Your Lordship, that a similar direction may be issued, Your Lordship, in the light of what is happening, Your Lordship, in the school, Your Lordship, from the very inception till the present day, Your Lordship, because it appears, I could understand, Your Lordship, from the submission advance, Your Lordship, even during the pendency of the writ petition, also certain appointments have been made, Your Lordship, whether those have been made with proper advertisement, Your Lordship, with the proper sanction or approval of the authorities concerned or not, Your Lordship, we are not aware. Only all this thing, Your Lordship, will be revealed only if Your Lordship is pleased to order an inquiry, Your Lordship. This would be my humble and respectful submission, Your Lordship. That's all, Your Lordship.
So, now, who's then? The other respondents?
I'm for the 6.
You're for?
Yes, number 6.
On 6. And who are you?
I'm the private respondent.
Private respondent.
He has been appointed, Your Lordship, during the pendency of the proceeding, Your Lordship. Lordship, I'll reply if required after the submission of the private counsel, Your Lordship.
Your Lordship, first of all, let the managing committee do. Standing to managing committee. We'll be standing on the affidavit by ourselves, but managing committee versus.
Okay.
I stand ready with the advertisement.
Yes, so
after putting the process, interview attended, then selected, then got the appointed as temporary basis in this official post, and then subsequently approval has come up. Then after due permission, government has given the sanction. So first of my appointment was there, and in the advertisement it was clearly written that if subsequently any post created or any adjustment is due. So the advertisement words were given prior to my appointment list.
heard Mr. Additional Learned AG. कोई का तो 4, 5, 6 ला देव नहीं पास नहीं कर रहे तो
7 to 11 ना
Yes, sir.
tangga tu kayu ka hearing saka jong ki private respondent ni lapas na pas 5, 6 lapas Mr. to I got 5 more. Mr. H. Abraham GA has submitted that the argument on behalf of the state respondent has been is concluded. No? The other private respondents have sought for time to respond. Accordingly, on preamble, this is matter after 1 week. Out of the 6 player, Mr. H. Kharmi, additional senior GA, PM for the state respondent has sought for time to sought for accommodation as far as the argument on behalf of the state respondent is concerned. The letter counsel for the respondents I to more 6 or 3. We need to check it again. Has also sought for accommodation. Accordingly, as straightforward, this is matter for the hearing on after 1 week. To 7 to 11.
11 your lordship.
Heard Mr. Additional Learned AG on behalf of the state respondent. Want to state respondent. Hearing argument on his part is concluded. Next, however, the legal counsel for the private respondents has sought for accommodation, has sought for time to respond. Accordingly, on payment, this is not after 1 week.
Apply your lordship. Then what's item?
Item number 12.
Your Lordship, on the last occasion, the petitioners have concluded a submission, Your Lordship.
You'll start first or I'll start?
Lordship, I'm the private respondent number 1. The respondent number 2 being the DC will be supporting the case of the petitioner. I wondered whether if it was convenient with the Honourable Court and the learned AAG, perhaps they could go first and I could respond to both of them at the same time at the end.
Okay.
Please, Lordship.
No.
Yes,
Lordship, first, Lordship, I would because the petitioner, Your Lordship, has already advanced the submission, Your Lordship. Besides that, Your Lordship, I would adopt the submission advance on behalf of the petitioner, Your Lordship, because we are the revenue authority, Your Lordship. Only thing, Your Lordship, I would like to add, Your Lordship. If Lordship kindly have page 78, Your Lordship, of the page 78, Your Lordship, that is paragraph 44. That is a plain, Your Lordship. That is the plain title suit number 25 of 23. Page 78, Your Lordship.
78.
78.
78.
78, Your Lordship. Yes.
78 is paragraph?
Paragraph 44, Your
44,
Lordship.
yes.
44, Your Lordship.
Yes.
Lordship, the admitted fact, Your Lordship, as per the aberment made by the respondent plaintiff here in Your Lordship, is that the cause of action, Your Lordship, arose on 20th/5/1994, Your Lordship. And Lordship kindly have page 25 or 85, Your Lordship. What is the area claim, Your Lordship?
Page?
Page 85, Your Lordship. What is the relief claim in the suit, Your Lordship? Yes. Lordship kindly have a page 28 or 85, Your Lordship, at A.
Yes.
Lordship, this is a declaration that the plaintiff was the lawful and absolute owner in respect of the property measuring an area of so and so, Your Lordship. So and so on the ground as per the private map, so and so, the total area as per the map, so and so, Your Lordship. And then, Lordship, taking from 94 onwards, Your Lordship, till date, Your Lordship, till the date of the filing, Your Lordship, of the till the date of the filing of the suit, the delay is almost 27 years, Your Lordship, from the course of action. Lordship kindly
delay.
Lordship, almost 27 years, Your Lordship. And before that, Your Lordship, before filing of the trial suit, Your Lordship, before the learned trial court, Your Lordship, the private respondent here in Your Lordship, he has come before this court, Your Lordship. If Lordship kindly have page 197. 197, Your Lordship. That is, he filed the writ petition in the year 2010, Your Lordship.
Yes.
2010. Before the then Shillong bench of the Honorable Guwahati High Court, Your Lordship, and this court by the judgment dated, Lordship, allowed the writ petition, Your Lordship. Lordship, kindly come to page 209, Your Lordship. Page 209, Your Lordship, paragraph 14. In the result, the writ petition succeeds. The respondent number 3, that is the Deputy Commissioner, Your Lordship, is therefore directed to demarcate plot number so-and-so recorded in the name of the petitioner in accordance with the finding of respondent number 2 in letter dated so-and-so, and thereafter take necessary and appropriate action for restoring that portion of the plot found to be encroached by the PWD in favor of the petitioner. Necessary and consequential amendments shall also be made by the respondent number 2 in the renewal lease deed dated so-and-so in respect of the plot in question after taking into account the encroached portion. The entire exercise shall be carried out by the respondent or 3 within a period of 2 months from the date of receipt of this judgment. Your Lordship, the PWD, Your Lordship, being aggrieved with this, Your Lordship, then file a writ appeal. Lordship, kindly have page 215, Your Lordship. 215. This is the writ appeal, Your Lordship, filed by the Public Works Department, Your Lordship, and the Honorable Division Bench, Your Lordship, by the judgment and order dated 30th/7/2014. Lordship will kindly come straight away to page 228, Your Lordship. Sorry, Your Lordship. Page 226, Your Lordship. Para 11.
Yes.
Para 11. Lordship, keeping in view the ratio laid down by the Apex Court in the cases discussed above and also the serious disputed question of facts between the parties, we are of the considered view that the present writ petition, where the right claimed by the respondent number 1 writ petitioner comes within the realm of private law, it is not the proper forum for deciding the right claimed by the respondent number 1 writ petitioner, and the proper forum would be the civil suit in the civil court of competent jurisdiction. Lordship, I would like to emphasize on this, Your Lordship, the civil suit in the civil court of competent jurisdiction. Accordingly, the impugned judgment dated so-and-so passed by the learned single judge is hereby set aside, and the result, the writ petition, is dismissed with above observation. Then, Lordship, against this, Your Lordship, what happened? Against this, Your Lordship, a special petition has been filed, and Lordship, that has been dismissed. Lordship, kindly come to page 228. 228, Your Lordship. Yes. This is the order passed by the Honorable Supreme Court dismissing the special petition, Your Lordship. Lordship, yes. Lordship, kindly see the judgment of the division bench of this Honorable Court, that is dated 30th/7/2014, and the order dismissing the specially filed by the private respondent herein, Your Lordship, that is 5/12/2014, Your Lordship. Then after how many years, Your Lordship? After almost 6 years, Your Lordship, the writ petitioner, Your Lordship. Before that, Your Lordship, what happened, Your Lordship? The judgment of the division bench, Your Lordship, is for the private respondent writ petitioner in that writ petition to go to the civil suit, Your Lordship, because since the matter involved disputed question of facts, Your Lordship, it required oral evidence, oral and documentary evidence to be determined by the civil court of competent jurisdiction. What the private respondent has done here, Your Lordship, in the year 2015, Your Lordship, he filed an application under Regulation 23(1)(c) of the Assam Land Revenue Regulation 1886, raising a boundaries dispute. Lordship will find at page 229, Your Lordship, in the writ petition, in another writ petition, Your Lordship. Lordship, kindly have page 229, annexure of 41. And that is the order dated 16/4/2021, Your Lordship. The short grievances made in the petition is that though the petition application under order Regulation 23(1)(c) of the Assam Land Revenue Regulation 1886 adopted by Meghalaya is pending before the respondent since 2015. Lordship. Lordship, kindly see, as I have submitted, Your Lordship, 2014 judgment of this of the division bench of this court is to the private respondent to go to the civil court, Your Lordship. To go to the civil court, rather what the private respondent has done, he filed an application, Your Lordship, under the Revenue Regulation 1886, raising a boundary dispute. When this petition was not acted or was not disposed of, Your Lordship, it took almost 6 years, Your Lordship. 6 years for the private respondent to approach this honorable court, Your Lordship, in WPC number 155 of 2021, Your Lordship, and by the said order, Your Lordship, there was a direction to the Deputy Commissioner to dispose of that application, Your Lordship. And accordingly, Your Lordship, that application has been disposed of, Your Lordship. After disposed of, Your Lordship, Lordship will find at page 233.
Yes.
Lordship will kindly come straight away to page 235 at paragraph 13 of that. Lordship, paragraph 12 and 13 is very important, Your Lordship, that therefore the applicant in preferring the instant application under Regulation 23(1) of the Assam Land Revenue Regulation.
You are reading para.
Lordship, I am reading at page 235. Lordship, I am reading at page 235, para 12 and 13 of the order dated 10 June 2022, Lordship, passed by the Deputy Commissioner, Shillong, Lordship. That therefore, the applicant is in preferring the instant application under Order 23(1)(c) of the Assam Land Revenue Regulation as adopted by Meghalaya is acting contrary to the express decision of the Honorable Division Bench in Writ Appeal number 2 of 2021. That as per the decision of the Honorable Division Bench, Writ Appeal number, the instant application is patently misconceived, is not maintainable, and also barred by law. That accordingly, on a consideration of the entirety of the fact and circumstances of the case in hand, and in particular in view of the judgment of the division bench in Writ Appeal number, the application of the applicant under so and so is hereby rejected, Your Lordship. Rejected. Then, Lordship, after this, Lordship, kindly see, then June 23, Your Lordship, then that title suit has been filed, Your Lordship. Then, Lordship, kindly, that title suit has been filed, and the PWD, Your Lordship, they file what they file, Your Lordship, an application for rejection of the claim. Lordship, if Lordship kindly see the impugned judgment at page 283, Your Lordship. Your Lordship. Page 283, Your Lordship. Then Lordship kindly comes to the finding of the learned trial judge, Your Lordship, at page 300.
Yes.
Lordship, kindly see paragraph 9 of that impugned order. Having heard the Land Council and after perusal of the plain and its annexure and pleading of both the parties, in this instant case, this court is of the opinion that the plain on the face of it discloses cause of action, and that the opposite party has been diligent in pursuit of obtaining the remedy for his grievances, for which rejection of the plain at this state on the ground of the no cause of action and bar of limitation were not justiciable in the given fact and circumstances of the case. Lordship, kindly, this is only a one paragraph finding, Your Lordship. There is no discussion on the law of limitation, Your Lordship. What is the starting point of limitation, Your Lordship? That has not been discussed. what is the prescribed period of limitation, Your Lordship? That has not been discussed, Your Lordship. What is the applicability of Section 14 of the Limitation Act? Also, that has not been discussed, Your Lordship. And the illegal part, Your Lordship, is done. Lordship is, I need not burden Your Lordship with the authority on that, Your Lordship, because in an application for rejection of the plea, Your Lordship, whatever stated by the plaintiff, the averment made in the plea will have to be considered only, Your Lordship, not the written statement or the statement made by the applicant, Your Lordship, in the application, Your Lordship. So, Lordship, kindly see, Your Lordship, paragraph, the pleading of both the parties, Your Lordship, this order, Your Lordship, in my humble and respectful submission, Your Lordship, is perverse, Your Lordship, not legally sustainable, Your Lordship. Because the learned trial judge, Your Lordship, cannot look in what has been stated by the defendant or by the applicant in the Order 7, Rule 11, Your Lordship. What the learned trial judge should see is what are the statement averment made in the plea only, Your Lordship. So my humble and respectful submission, Your Lordship, this is a fit case for remand, Your Lordship. The order is required to be interfered with, Your Lordship, and the learned trial judge may be directed, Your Lordship, to re-examine and to rehear the matter, Your Lordship. This would be my submission, Your Lordship. Highly obliged, Your Lordship.
Please, Your Lordship.
Come here. Just come here.
Please, Your Lordship, the petitioner respondent had challenged the plaint on two grounds. One was that there is no cause of action under Order 7, Rule 11. One is that there was no cause of action. The second was the suit was time-bound and it was beyond limitation. As far as the first argument of the petitioner was concerned, they did not really press it, because I think by the end of it, it was accepted by the judge also in the impugned order that there is a cause of action. So the main battleground, so to speak, Lordship, was basically the issue of limitation. So before I delve into the facts, Lordship, if I may take Your Lordship to the relevant law on limitation, Lordship may have the Limitation Act. Sorry. Please, Your Lordship, arrangement of Sexual Limitation Act.
Yes.
Lordship, it is not in dispute that the cause of action arose first in 1994. That was not something that was disputed either by the defendant, petitioner-defendant, or by us. We said that we first knew about an encroachment into the plaintiff's property in 1994, and it was certified, and we actually had actual knowledge of that encroachment in 1994. So if any clock has to start, it will start in 1994. There's no difficulty about that. The difficulty or the main argument between my learned friend and I was essentially which section of the Limitation Act does this case fall under. My learned friend says it falls under Article 58. If Lordship may have Article 58 of the schedule.
It's already
highlighted.
Rounded, Your Lordship. Lordship, can you have that 58? It's already rounded.
Yes.
Lordship, yes.
Please, Lordship. So the petitioner's argument before the learned trial judge was that this suit is covered by Article 58 of the Schedule to the Limitation Act. Article 58, if I may read, Lordship, it says description of suit to obtain any other declarations. What they mean here is a declaration for title, for instance, or a declaration for something else, or for some partition or whatever it might be. The period of limitation is 3 years. And the time from which the period begins to run is when the right to sue first accrues. My learned friend's argument was essentially that given this particular article, the right to sue accrued in 1994, and 3 years has since lapsed, and we are woefully out of limitation. Our argument, Lordship, on behalf of the plaintiff, is that we're not covered by Article 58, we are covered by Article 65. If Lordship may have Article 65 of the schedule.
Yes.
Now, Article 65, Lordship will see description of suit for possession of immovable property or an interest therein based on title. I would stress this provision based on title, because, Lordship, I will show you. I will come to it, Lordship, in due course. But the fact of the matter is, the title of the plaintiff was never disputed. What was disputed was basically the amount of land that fell under his title. So our argument before the learned trial judge was that it is Article 65 that governs this particular case. Now, that being said, what is the period of limitation? Lordship will see. The period of limitation is 12 years, and when does the time begin to run? When the possession of the defendant becomes adverse to the plaintiff. So here what we have, Lordship, is that unless the defendant argues adverse possession, the clock does not start running under Article 65. Particularly in a situation where the title of the property is not disputed. The amount of property under the title is under question. So in that sense, Lordship, if I may refer your Lordship to the prayer in the suit to delve into this a bit further. Lordship will see that the suit is not a suit for title. It is not a suit for declaration of title. It is a suit where I have a lease deed in my possession. But the amount of area under that lease deed is what is under question. So we are governed by Article 65. That was our first argument, Lordship. The second argument in the alternative, Lordship, was that even if accepting that Article 65 does not apply to the present suit, we fall under Section 14 of the Limitation Act. Now, if Lordship may have Section 14. Lordship may have Section 14 of the Limitation Act. Lordship has it?
Yes.
Huh? Right. So Lordship will see that Section 14 was our alternative argument to Article 65. Section 14 states thus: exclusion of time of proceedings bona fide in a court without jurisdiction. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, Lordship will mark it not a civil suit, but a civil proceeding. This is important again because I will refer your Lordship to proceedings under the revenue regulations and show that those are civil proceedings. Whether in a court of first instance or appeal or revision against the defendant shall be excluded, where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court from which defects of jurisdictions or other courts of the like nature, it is unable to entertain it. So the sum and substance of this, Lordship, is that if I have been pursuing a matter in a different court, the matter being exactly the same matter at issue in the present suit, that period where I've been pursuing that matter in the wrong court of the wrong jurisdiction, that period should be excluded. Now, our argument before the learned trial court was, one, we fall under Article 65. If we fall under Article 65, unless the PWD raises a claim of adverse possession, the clock on limitation does not start. And in fact, I will place certain authorities before your Lordship to show that the government cannot, by law, raise a claim of adverse possession in the first place, even if they wanted to, which they admittedly did not. So the argument was very plain and simple that Article 65 therefore covers the instant suit, and therefore we are not barred by limitation. In the alternative, Lordship, if I may refer your Lordship first to the plaintiff's lease agreement over this property, the most recent one. The lease agreement is at, if your Lordship will bear with me. Lordship may have page 210 of the revision petition.
$210.
210.
The lease agreement.
This is the lease agreement, Lordship. Please, Lordship. And if Lordship may have paragraph 8 of the lease agreement, which is at the first page, right at the bottom.
Yes.
Now, before I proceed, Lordship, why is this a lease agreement and not a sale agreement? The reason being because the government is a freehold owner of revenue land. I hold a lease that is granted to me by the government for a certain period. It could be 90 years, 99 years, etc. But the freehold owner is the state, is the sovereign, the state. Therefore, I hold a lease agreement rather than a sale deed or any other kind of patta or dulir or whatever it might be. Given that, Lordship, the fact of the matter is, since the state is a freehold owner of the land, who is the manager of this land? The manager of this land is the Deputy Commissioner, who exercises his managerial control over all revenue property under the Assam Land and Revenue Regulations. Any dispute, any situation between two landowners, for instance, or encroachment onto revenue land, the leaseholder has to go to the Deputy Commissioner under the Assam Land and Revenue Regulations to ensure that any problems are sorted out and dealt with under that particular regulation. Now, if Lordship sees paragraph 8, it reads as thus: that in the case of a dispute arises regarding the boundaries, the Deputy Commissioner or his representatives shall cause the boundary marks to be erected, if necessary, after survey, and the cost and erection of the boundary marks shall be borne by the lessee. The decision of the Deputy Commissioner in this regard shall be final and binding. Now, this is a provision of my lease to say that if there's any boundary problem with your neighbor, say in this instance, it is plot number 18, European Ward. The PWD allegedly, although I will get to that eventually, Lordship, the PWD allegedly is on plot number 19, an adjoining plot. So, if any boundary dispute occurs between two leaseholders of revenue land, the lease agreements are very clear. You have to go to the Deputy Commissioner and he will sort out this dispute. Now, under which section provision does he sort out this dispute? There is a procedure prescribed, Lordship, and if Lordship may have the Land and Revenue Regulations. And if
You have given the list of books.
Lordship, I'd given a list of judgments, not the list of books. My apologies. She was. My apologies, Lordship. I wasn't aware that was a requirement. Learned age, you just corrected me.
That is for, you see, for our reference.
In that case, Lordship, if we have this another, if your Lordship would wish to have this another day, I will submit a list of statutes and authorities. I'll leave it to your Lordship.
You should have done that beforehand. We will keep this part heard.
Please, Lordship.
Heard Mr. Indishulai AG for respondent number. You are respondent number 1.
I'm respondent number 1, Lordship. My learned friend EG is...
Respondent number 234, Your Lordship.
Respondent number 2, state respondent number 234. Next, also heard Mr. PSD, Direct Counsel for respondent number 1. Please. Matter hearing will continue as paid for by the parties. Hearing will continue next day. This is matter of 2 weeks.
Briefly, Lordship.
Apply, Your Lordship.
Lordship, if I may make a request that it comes high on the board.
That is not for me to.
Lordship has that power.
I may have the power, but I don't do. I don't.
Please,
do
Lordship.
I don't do the math.
Please.
But you can request, sir.
Item number 15.
Grateful, my lord.
I'm aware of that.